Secretary, was the meeting posted?
Yes.
Item number 1 on the agenda, please.
With respect to the minutes of the meeting of October 9th, 2014.
Any discussion from the board?
Moved acceptance.
Motion by Commissioner Krieger, seconded by Commissioner McCarthy, accept the minutes. All in favor signify by saying aye. Any opposed? Motion carries. Number 2, please.
Commission will now take up matters to do with special one-day license applications for malt beverages and wine only, or either one, starting with Tracy Martino of Aramark for Saturday, October 25th, 11:30 a.m. to 3 p.m. is the event for the Soccer Alumni Barbecue to be held at the Cushing Complex, the North Campus of the UML, University of Massachusetts Lowell. It will be within a rented tent with bike rack to contain area, staff to be posted at the entrance and exit. Also, Tracy Martino of Aramark has an application for Thursday, November 13th, from 2:30 p.m. to 8 p.m. for the New England Plastics Group Dinner to be held at the ETIC Atrium at 40 University Avenue. Jim Lucullus for Friday, October the 31st, from 7 p.m. to 12 midnight for the Zombie Party Massacre Night at the Luna Theater at 250 Jackson Street. Gabriel Davis for Friday, November 14th, from 5:30 p.m. to 10:30 p.m. for the Craft Beer Walk at 250 Jackson Street. Also, Michael LaChance of the Merrimack Repertory Theater at Liberty Hall, 50 East Merrimack Street, for the theatrical performances to be conducted by the Merrimack Repertory Theater for dates beginning October 23rd through the 31st of October, then starting up with November 1st through the 16th. There are 19 dates in total, and there's a concession sales and service for 45 minutes. One of the dates, that being October 30th, it's requested that the pre-performance concession be for 90 minutes. That's October 30th. And then there would be, for each and every date, there would be a 15-minute intermission where beverages would be offered. Also, Jeffrey Prescott of the Merrimack Repertory Theater for the events at the Liberty Hall, 50 East Merrimack Street, for theatrical performances by our Merrimack Repertory Theater for November 28th through the November 30th, December 3rd through the 21st, 18 dates. One of the dates would be December 4th, which, again, there would be instead of a 45-minute pre-performance concession, it will be 90 minutes, and then there would be the 15-minute intermission. Those are the applications for malt beverages and wine only, or either one.
Could everyone approach the lectern and introduce yourselves for the record, please?
Tracy Martino, Aramark.
Gabrielle Davis with 127 Global.
Jim Lucullus, Luna Theater.
Jeffrey Prescott, Merrimack Repertory Theater.
Michael LaChance, Merrimack Repertory Theater.
Good evening, everyone. Tracy, you've held many licenses here before, I know that.
Yes.
All right. Looks pretty straightforward on those. Thank you very much. Mr. Lucullus, the Zombie Party Massacre. How many people do we feel they're going to be here?
The theater can hold 85 people, so
You expect 85 people?
I would hope for 85 people.
Okay.
We'll see.
Ms. Davis, how are you?
Good, how are you doing?
Don't think I've seen you here before. Is this going
I
to be?
have been,
you
the
have
Lowell
been.
Food and Wine Festival.
Okay, I'm sorry. And this is for the craft beer work. Can you tell me
Yes,
about?
it is.
Can you tell me about that?
The Craft Beer Walk, we're going to be selling tickets for $15. It's at mill number 5 on the 4th floor, 250 Jackson Street. What else do you want to know?
How many people do you feel they're going to be?
We're going to be expecting, we're hoping to expect 150 people.
150. Okay. Now this is not the. Mr. Lucullus has 250 Jackson Street, number 490. You have the complete set 4th floor. Is that?
Yes,
All right. Thank you. And how many? What's the occupancy on the 4th floor?
I'm not sure.
Mr. Lucullus, could you help her out with that?
I think about 500 throughout the floor. Yeah.
Thank you very much. Mr. LaChance. 90 minutes prior a ladies' night? What is that, Ryan? Because I know,
Well,
I know
apparently,
Commissioner Krieger
there-
might want to go to that, that's why.
Yeah, Merrimack Repertory Theater has certain promotions during their performance season.
Yeah.
And I think there are 2 dates for each theater production they're offering.
Yes.
The one that's to begin this evening, as a matter of fact, and then the next one that will begin November 28th. So in anticipation of those 2 productions, they apparently have a certain promotion.
Okay.
They define it as ladies' nights.
Thank you. Mr. LaChance, Mr. Prescott, both have held licenses here before, I imagine, right?
Yes, sir.
All right. Questions from the board? Comments?
Make a motion, we accept?
Commissioner Krieger, you have any comments?
I was just wondering why you go for individual licenses instead of one big license for the year.
I'm not sure, sir. I've been with the company for 4 years now, and this is the way it's always been done.
Commissioner Krieger, if I may interject 1 second on that subject. Merrimack Repertory Theater has limited use of the Liberty Hall, and under the, they have a license agreement with the city to utilize the space. Presently, the facility, the building itself, the auditorium has an annual licensee that's held by the Lindsay Group, if I may. The MRTA has looked into the annual license, but the facility and the setup at the present time and in recent years has not lent itself to an annual license. It would mean having a license agreement with the city of Lowell to pursue the annual license. It would also, I should also point out, the distinction between the auditorium and the Liberty Hall, which is the site for the Merrimack Repertory Theater's production, is that the auditorium has an annual license which does not fall under the quota of licenses the city licensing board can grant, meaning to say that that license is strictly for the auditorium, and it's not to be, it cannot be changed to another location. So even if the concessionaire for the auditorium should change, the license will always be available for that facility, whereas that would not be the case with the use of the Liberty Hall. So if you were granting an annual license to the Merrimack Repertory Theater, what is stated in state law under Chapter 138, Section 12, would mean that this licensee would have to have business hours, much like a bar or restaurant would have. There would be no exemption on that respect if you wanted to follow the letter of the law. Also, the fact that the Merrimack Repertory Theater is a licensee, if it be the case, could transfer or change its location of that license to another building in another location if they wished. So, all that being said, it has been a standard practice for the Merrimack Repertory Theater to accept the one-day licenses. In fact, the licensing board and previous members have granted licenses such that it would be for the date of a performance, and so that they may have, in some given days, they may have more than one performance. There may be a matinee on a, let's say, I'm just speculating, on a Saturday, and then an evening program as well.
Yeah.
So that one-day license for the fee that they pay is $10.
That's always been the way, though, right? Huh?
I'm sorry?
That's always been like that for that. for
Ever
Liberty
since
Hall.
the Merrimack Repertory has been in operation there with the request to have a beer concession or a wine concession.
Yeah, makes sense. Any further questions or comments from the board? I have a motion from Commissioner McCarthy, seconded by Commissioner Krieger to accept. All in favor signify by saying aye.
Aye.
Any opposed? Good luck with all your events.
Thank you.
Thank you.
Commission will now take up matters to do with special one-day license applications for all alcoholic beverages, specifically Gilhermina Meneses of the Holy Ghost Society. For events at the Holy Ghost Park at 65 Village Street, there are 5 applications that Mrs. Meneses has filed, starting with Saturday, November 1st, from 6 p.m. to 1:30 a.m. for the event at Peter Suarez fundraiser. Also, Ms. Meneses has an application for Saturday, November 8th, from 5 p.m. to 1:30 a.m. for the event is the Sylvia's 90th birthday party. There is a Third application for Saturday, November 22nd, from 6 p.m. to 1:30 a.m. for the St. George Dinner Dance. Also, Ms. Meneses has an application for Saturday, November 29th, from 6 p.m. to 1:30 a.m. for the Eddie Casella Dinner Dance. And last is the application for Saturday, December 6th, at the Holy Ghost Park, from 6 p.m. to 1:30 a.m. for the event, the fundraiser for the Holy Ghost Society.
Could you state your name for the record, please?
Guilherme Nemnitz from Holy Ghost Society.
Good. You were here a couple of weeks ago for some licenses. How did those events turn out?
Perfect.
No problems?
No problems.
All right. Questions or comments from the board?
Move to approve.
Motion by Commissioner Caprow, seconded by Commissioner McGovern. All in favor signify by saying aye.
Aye.
Any opposed? Motion carries. Good luck with your events.
Thank you.
Commission will now take up an application for a special events permit for amplified outdoor public entertainment. The Smith Fest events, Frederick Smith representative. For the Panic in the Dark at Shed Park, amplification permit for ambient Halloween sounds on Saturday evening, November 1st, from 5 p.m. to 10:30 p.m.
State your name for the record.
Frederick Smith?
Mr. Smith, how are things?
Very good, thank you.
Good. Tell us about your event.
Panic in the Dark is a nighttime 5K event that runs through Shed Park and Fort Hill. It starts at the auditorium. We bus about 1,000 patrons to Shed Park and then back to the auditorium for an after party.
Had this last year, didn't we?
This will be the third year.
Third year?
Yep.
No problems with the last 2 years?
No issues.
Captain Kennedy, any comments?
No, as far as I know, Mr. Commissioner, there's been no problems with the event.
Thank you. Questions or comments from the board, please?
Move to approve.
Motion by Commissioner Krieger, seconded by Commissioner McCarthy. All in favor signify by saying aye.
Aye.
Any opposed? Motion carries. Good luck with the
Thank you.
event. Thank you.
We have two communications, first being from the Superintendent of Police, William M. Taylor, dated October 17th. Allegations at Camilla LLC, doing business as reservations, George Torres, manager, the all-alcoholic beverage restaurant licensee, was in violation on October 9th of Section 1.06 and Section 1.16 of the Alcohol Beverages Regulations for licenses issued by the Lowell License Commission. Also, which is the primary communication which Superintendent Taylor has included in his communication is from the building commissioner, the deputy chief Lowell Fire Prevention, and the senior code officer, dated October 15th, regarding the inspection, which the superintendent's letter is referencing to Reservations Lounge at 179 Central Street. And this was an inspection that had taken place on October 9th, 2014.
I've read through the complaints, and I've read what the DPD had sent out as well. And the memo concerns me a bit. And the memo was from Mr. Shanahan and Deputy Chief Gilligan and Mr. Willett, the senior code officer. And it seems to me that this board has not heard about any of these prior infractions, and they look to be serious in nature. And that worries me a bit. Be that as it may, seems like we've had Mr. Torres here for visits quite a bit lately, and I think we need to see him one more time. But I'd also like to have Mr. Shanahan and Mr. Willett present at the next meeting, and if we could do that for, was it November 6th, Ryan?
We can schedule it for that.
At this point, reservations is still not open. Is that true, Captain Kennedy?
My understanding, Mr. Chairman, they have reopened. The issues identified by Mr. Shanahan and Mr. Willett have been corrected, at least temporarily, and as it stands right now, they are open for business. That's my understanding.
Do you know when they reopened?
I'm sorry?
Do you know when they reopened?
I believe it was last Thursday or last Friday, if memory serves me correctly.
So I think, if I may, just,
Sure.
Chairman Dakota, is this, these inspectors have the wherewithal to go into any licensed establishment and, for cause, close the business forthwith. Whereas the licensing board here in the city of Lowell has to go through a formality of notice of hearing to even consider taking a suspension of license, so that I think the basis of the notice from the inspectors, which Superintendent Taylor has referenced in his communication, is that this particular licensee has failed to make the premises available to inspectors when they need to go in and do their routine, their work. Normally, you would anticipate a licensee being open 9 to 5 minimum, 7 days a week, or at least 6 of the 7 days of the week, not including Sunday, of course. But this particular instance, in this particular licensee, apparently the inspectors, in their attempts to access the premises, have not had any means to contact the management. And the management has obviously set its dates of operation such that I think they're operating Wednesday evening through Saturday evening is their primary business hours. So that's not conducive to having an inspector coming in on a Thursday night at 6:30 unless they're doing some type of a surveillance of crowd check or something of that nature. So I think this is the point of the complaint, and I think whatever the inspectors have done to allow this business to open, they have the wherewithal to do that.
Well, it seems like Mr. Torres hasn't been so accommodating with our local officials entering his premises, so I think a meeting of the minds might not be a bad idea.
Right, and this is not uncommon for some of our licensees where they need to make sure, like, for example, the wiring system to their alarm has to be functioning at all times, and sometimes that system may not work properly. There may be an alarm that goes off, and we've had an instance in the past, in a recent year, where a licensee has chosen to turn off the alarm system without the proper protocol, and that's troubling to the fire department.
Any other comments from the board?
Yeah, Mr. Chairman, could we have the owner of the establishment come in too?
Why don't we have Mr. Torres come in at our next meeting? Secretary Nguyen.
Okay.
Is that is that agenda pretty full, or?
Well, circumstances of the next meeting could be complicated because of the 2 applications that are for transfer of license to do with Brian's Ivy Hall and Finn's Pub. Those 2 applications, as it stands right now, they're scheduled for public hearing. There's legal notices to be published in local newspaper tomorrow afternoon, or tomorrow morning, I should say. But there are certain aspects to these applications that are still need to be addressed, at least as far as I could tell as of this afternoon. This may be an issue with the License Commission's actions on any favorable action they wish to take or consider taking on such an application. So
I don't think it's going to take a lot of time.
Okay.
Commissioner Krieger, Commissioner McGovern, Commissioner Hogan?
Mr. Chairman, if I may, my understanding through communication with Mr. Shanahan is that he made repeated attempts to contact Mr. Torres to access the premises for the inspections. Those efforts failed for several weeks. They were finally successful in getting in there, which resulted in the citation from the city. Mm-hmm. But again, for the record, it is my understanding Mr. Shanahan made many attempts to contact Mr. Torres and get him on the premises so an inspection could be conducted.
So be it. Let's extend an invitation to Mr. Torres at our next meeting.
So the motion is, I'm sorry.
Motion is to have reservations come before the board on November 6th at our next meeting concerning actions taken by him with regards to local officials.
And
Does that sound right to you, Attorney Veloso?
That can be fine. It can also be to address the communications for the the allegations that have been issued by the superintendent of police as well.
Thank you. Anything further from the board? All set, Ryan?
So may I have, who made the motion? I'm sorry.
All right, make the motion by Commissioner McCarthy, seconded by Commissioner McGovern.
Okay, thank you.
All in favor, signify by saying aye.
Aye.
Any opposed? Motion carries. We'll see Mr. Torres at our next meeting.
Okay. That concludes the typical and regular business of the licensing board. Commission may now wish to open a public hearing to review the revised alcohol beverage regulations for licenses issued by the Lowell License Commission. This revision took place, approved by the board on April 25th, 2013. There have been no changes to those regulations since April 25th, 2013. And I think it's the intent of the board that this allow for public comment.
Have people registered to speak, Ryan, or should we just kind of, do you have anybody who has already?
No one has
Okay, that's fine. All right.
expressed interest, but I think it's been practice of the board to just allow those individuals who want to offer comments to approach the podium.
Obviously, there's quite a few people here, and this is the last agenda item, so whoever would like to go through the lectern first and express your comments, suggestions, that's what this is basically. We're looking for some input from the public, licensees, experiences that you've had in the bar business, or even just patrons. Please come to the lectern, state your name, and feel free to speak. Somebody needs to be first here.
Want me to list mine to?
Commissioner
Some of
Krieger
ours.
does have some items, and some are grammatical, I imagine, but some are some other issues.
Yeah, I'll skip the formatting issues because I think that that's something that Ryan should look at and maybe we can talk about next week. And then I have some edits for grammar, about a page and a bit, but substance. Paragraph 1.06, this is probably more just a question I have, which says that we can suspend the license for failure to pay taxes. And my question is, will the courts allow us to suspend a license for failure to pay taxes? Do we know, do we have a sense of that?
Attorney Veloso?
With my discussions with counsel for the ABCC, the advice we got on that point was that in terms of failure to pay taxes, it's certainly an issue that can be brought up with the licensee. And my understanding from counsel for the ABCC was that a reasonable opportunity should be granted to the licensee to rectify that situation before disciplinary action is taken. Now, the amount of time that can be taken in order to grant them the opportunity to pay the taxes, that's up to the discretion of the commission. However, that was the recommendation that a reasonable period of time be granted to rectify issues such as taxation or filing of the like before potential disciplinary action or revocation is taken.
Was this a lawyer you were talking to?
Yes, this would be counsel for the ABCC.
So this is sort of a elastic period that,
I would say it's more to take into account on a case-by-case basis. Sometimes, some situations you may be dealing with a licensee that is refusing to pay the taxes that they are required, and in the License Commission's discretion, they can deem that this continuous refusal to pay taxes is egregious and certainly not a lapse or an occasional instance of forgetfulness.
So you're saying if they have a plan, we should give them space, but if they don't have a plan, we can cut them off?
It's certainly within the discretion of the commission. That can certainly be a position that you take.
Okay, thanks. I don't know if anybody outside wants to talk about that. I don't see anybody rushing. My second one was paragraph 1.13, which has to do with display of licenses. Sometimes I wander into a place and the license is not obvious or on display. This seems like it's important, but I may be mistaken. Do we, is this something we should be out, all of us enforcing, or is this one of those things that we're just adding a burden that brings us a little bit of ridicule because nobody does it?
If I may, Commissioner, it would certainly be my position, it would be my position on reading of the law that it is certainly not an unimportant consideration. The fact that a license holder must have a license prominently displayed in their premises is not only a requirement under state law, but it's also a protection for the license holder to the general public. It shows to the general public that they are authorized by both state and local authorities to serve alcohol. If a license such as that isn't prominently displayed, it's certainly not only a violation of state law, but it can also place them in danger of not only losing their license, but also potential liability should any harm come about from the serving of alcohol and so forth. So
The readability requirement suggests that maybe we need to make the font size a little bit bigger so that I, on my side of the counter, can read what's on the other side. But I invite you to walk with me to a couple of places and we can see what it looks like. Paragraph 1.21a, line 3, which says that if a place allows someone to leave drunk, and that happens 3 times inside of 6 months, I believe, are we talking one individual, or are we talking any 3 individuals? That wasn't clear to me, and I think my recommendation is that we change the wording to the court by 1 or more individuals that said they were served alcohol, so that it's not just one person, but it's clear that if 3 different people get drunk in an establishment and get pulled over by the police inside of 6 months,
May I
that's a
just
violation.
offer some background on that situation, if I may? It had been the standard practice of the district attorney's office to send notice to the licensing board when, and I think by statute, and I'm sure Attorney Beloso would be able to confirm this, that if you were brought in before the court and the judge for driving under the influence, apparently the law was that the judge was to ask you, I believe it in the context of where did you have your last drink, or something to that effect. However, there had been apparently some sort of a problem, because if I was brought before you, Judge Krieger, and you'd asked me the question, I said I had my last beer at Joe's Pub, but I never walked into Joe's Pub. But I just said to you, Your Honor, Joe's Pub. The district attorney's office would send the notice to the licensing board that immediately by name, Ryan Wynn had been last served when he told the court at Joe's Pub. But that is not like, how should I say, it's not certainty. It's not a certainty in the court, and not in the certainty as far as the way the law reads, as my understanding. However, so the district attorney's office would send you the licensing board notice. So if I was going and getting caught 3 or 4 times under the influence, and I kept coming before you and saying, Joe's Pub, Joe's Pub, Joe's Pub, suddenly you know that there's a problem at Joe's Pub. Something's going wrong with that business, and so there was the issue. And so at this point in time, I should just cut to the point. There have been no communications from the district attorney's office in recent years. However, the the merits of this regulation, when it was proposed several years ago by the License Commission, when it's actually originally part of the rules before the revision took place, was to put the licensees on notice that if your business is being cited by Ryan Wynn 3 times or more, then we've got a problem with you, and you've got to clean up your act as far as sale and service is concerned, not serving intoxicated people. I think that's the point of that.
So do we think that things are actually good in Lowell, or do we think that things are not so good in Lowell, but the DA is just not doing much for us?
You wish to comment on this?
I
Matt?
do, I'm sorry, I don't mean to interrupt.
State your name for
My
the
name's
record.
I'm Matthew McCarthy. I'm the manager over down at the Hookside Kelly's, which is trying to transfer over to Dudley's. The only question I have is, how do you know, like, where they really had the last drink? I mean, how, unless you can show they actually drank there. And I know you could pull receipts and credit cards, things like that, which I would assume the district attorney officer would do. But to have it just be an arbitrary, whatever they say, they had the last drink and you get suspended, it doesn't seem to be fair to licensed establishment, if you ask me. Because there's no way of proving, unless we have some way of showing the person was definitely drinking there, got intoxicated there, and that's the reason they got pulled over and had the problem. I don't see how the licensed establishment can be held responsible for that.
Attorney Veloso, do you have a comment to Mr. McCarthy's concern?
Well, I certainly can't speak as to sort of the policies of the district attorney's office in terms of the issuance of reports.
But his concern has merit. I mean,
There are certainly some points of it that can be merit. I think the point being, what if one person became intoxicated at one establishment, then went to another establishment and drank some more, and then proceeded to get into a car accident or had a driving under the influence.
Especially, like UMass Lowell or any other college, they have these pub crawls, and, you're attending 5 different bars during the day. And you start at 10 o'clock in the morning, and you have 7 drinks at the first one. Well, I imagine at that point, you're pretty well intoxicated, even if you're at 3 o'clock in the afternoon where you've had another 10 more.
Mm-hmm.
You know what I mean? I think there's,
But doesn't this go to our ruling that people should not be overserved?
Well, it certainly goes towards the License Commission rules and regulations and state law that prohibits the serving of patrons that are intoxicated. So certainly if there were a situation where, as you said, a student at a pub crawl consumed 7 beers and was intoxicated, if they went to another establishment, it certainly would be upon the establishment, if they observed this person to be intoxicated, to cease service for that intoxicated student. So I suppose in that aspect, the law is pretty clear, and our rules and regulations are pretty clear in terms of just the serving of intoxicated patrons. But we can certainly take a look at that section. So.
okay.
Yeah, if it's already covered, and that's why I think we need to take a look at it. If it's already covered, there's no point in having it. If it's not otherwise covered, then there may be some value, but I would think if we're going to talk about it, it should not be one individual, but a number of individuals pop up on the radar in a 6-month period. I think that would be indicative of a problem. Okay, so we'll take a look at that. And I agree with you, Mr. Chairman, that Mr. McCarthy's point is excellent. If we go to enforce this, we need to be careful we respect the rights of the licensing place. One citizen suggested to me that the License Commission mandate video cameras after any infraction involving physical misconduct. This is paragraph 3.01. I think that something that says that the License Commission may impose a requirement for video cameras in the event of some findings might be worthwhile to add to the regulations.
I see some license holders in the audience tonight. Anybody have any comment before the commission comments on this? Okay.
Whoops, we got one.
We got one. Could you state your name for the record, sir?
Nick Petrakis, Blue Shamrock Pub. I think most of the establishments have looked into video cameras. It's not a cheap, most people, even without the infractions, I'm sure, most people have contemplated putting them in. It's not a cheap thing to do. You're talking thousands of dollars, and I don't know about other people, what they're making and stuff, whatever. We're not, the profit margin right now in the restaurant business, with all the hospitality businesses, disposable income's down, so, I mean, we're cutting corners everywhere, you know what I mean, that we can without jeopardizing anything, including safety, so, I mean, it's a huge expense. So it's not something, you know what I mean, that's easy to say, go spend a couple $100 and put this in, because then I think everyone would do it. So I think to mandate it, it'd have to be, really required by the board, you know what I mean, have some good reason, which I'm sure, I'm not saying you wouldn't have a good reason, but I mean, some real good reasons, because it's a very expensive proposition.
I think Mr. Petrakis brings up a good point. When we are talking about establishments that it may be their first infraction or second infraction, but it does concern me that if we do have an establishment that has had frequent incidents, I think the discussion has some merit here, where we are protecting the bar owner as well, and may even have a solution to your question there, Mr. McCarthy, is that, once we do get, if somebody does have a video system in their bar, and that person who came in after going to 3 different other establishments says they went to your establishment, when in fact, they've never stepped a foot in your place. So, I mean, I'm kind of like this when it becomes, like Mr. Petrarca just states, I mean, you're not going to buy a video system for $200. I mean, this is something that's going to cost a couple of thousand, if not more, in the maintenance of such a system. So I'll leave it to the board for further debate, but there's arguments to be made on both ends, I believe.
If I may also, just in past discussion on this subject in particular, and I think there was some concern previously by a member of the commission at the time, who's not on the board at this present time, about civil rights issue, and that had something to do with the manner in which this, the language of special conditions was conformed to, not to make it, it would be like a scenario where, as you were just pointing out, Chairman Dakota, is that if you have repeated infractions, repeated reports from the police department of certain actions, activities on the licensed premises that might justify the licensing board coming to that point in time where special conditions such as a video for, say, the entrance to the establishment as to who's entering the premises and how they're exiting, in that, something of that nature. I'm just speculating, that's just a hypothetical, as opposed to having it in the over the bar as people are mingling and socializing.
I actually quite agree with that. I mean, I think if it does come to that point, the licensing board can make that decision for the proprietor. But to dish out that type of money at the, while you're trying to make a buck, and as Mr. Petrarca said right now, we're all in lean times here. That might not be the best move at this point. But any other comments from the board concerning this? Anybody else from the audience? Why don't we move on, Mr. Green?
Okay, paragraph 4.02 is about hours of operation, and so we have to change Sundays from 12 noon for package stores to 10 o'clock in the morning. And that should just be sort of a one-time move to change that. Are we requiring people to submit to change their hours?
Well, here's what I've tried to convey to the licensees, and since this law was adopted, is that the ABC has this advisory, and the advisory is asking the licensee to notify the licensing authority that they wish to have their sale from 12 noon to 10 a.m. on a Sunday, starting this Sunday, actually, October 26th. Point being is that they want a record, they want a paper record of the request and the change. They want the licensing board to have something on file that says that your package store licensees in the city of Lowell have all agreed that they will operate, or they will be willing to open as early as 10 a.m. if they wish to sell that early on a Sunday morning. And it's just that.
Well, I think what Mr. Krieger's trying to get to, Mr. Nguyen, is, are they asking or are they mandating?
The law is the law. It's 10 a.m., and it goes into effect October 26th.
Okay.
It's just the ABC's way of addressing it and to create a formality of the change so that if you're a corporation, let's say it's a corporate, let's say you're the sole proprietor of your package store. You're an individual, you want to sell at 10 a.m. on Sunday, that's your business. But in a corporation, it may be a little bit more involved, and so that there may be 3 or 4 directors in the corporation, not all of whom agree that they want to be open at 10 o'clock on a Sunday morning.
So the ABC is, once again, not being definitive with us.
Just kind of saying, give us an authorization that this corporation holding the liquor license wants to be open at 10 a.m. on a given Sunday.
But we have no authority to deny this, so all they're really doing is giving us a note saying, we're going to be open until 10 o'clock.
But the state
Right.
legislature made
already-
the law.
it's already
The
a law.
governor signed that bill.
You have anything to add to this, Attorney Veloso?
Only that it is state law, that once the governor signed it, that is the hours in which an establishment can, authorized under 4.02 is allowed to operate.
Once the governor signed it, plus a certain amount of time in this case.
Well, correct.
Yes, Ann
I'm bitter
Tavalaris.
about that.
I'm the Ann Tavalaris. I'm the XL Package Store up the street on Merrimack. Exactly, the form you downloaded from a website if you wanted to be open. You then filled out the application for the change of hours. The law was the law. It seemed more like to me that we were in a position, whoever did want to do that, because, some people 10 a.m. on a Sunday morning with 11 p.m. every day and 8 a.m. through the week may or may not choose to do that. So whoever wanted to do that took it on themselves to do the form, send the form in to Ryan. Ryan then sends it to Boston, and that's giving the local authority the understanding of who is opening and who isn't. So I'm on file as wanting to be open at 10 a.m. this coming Sunday throughout. If people don't want to or don't take advantage, to let the local authorities know. So everyone that's open that's the way I saw it anyway. So every package store that wants to be open at 10 a.m. Sunday should be on file for you to see.
Right.
So that's kind of where I saw it more than, it was giving you guys the authority, to know
Appreciate
who's
that,
there.
thank you. How many package stores have sent you correspondence?
All of the corporate licensees have. Some of the sole proprietorships haven't. I've spoke to one individual this evening before the meeting convened and just asked for some kind of a communication, just to put it on record so that I can send it to Boston to say that this business, this particular licensee, will be opting to open at 10 a.m. or will open at 10 a.m. on a Sunday. It's just a kind of a paper record.
Could you, for the people that don't,
If they didn't do it, I wouldn't suggest to the commission and
Right.
ask the Lowell Police Department to do it.
no.
No.
But maybe you can get in contact with them as government
I will
oversight.
follow up with a communication, just to let it be known, if they could just communicate on a letter form, if,
That's fine,
It's just a notification, it's not an application.
right.
that's correct. It's just, we know that the corporation.
Thank you very much.
Okay, moving along, paragraph 7, decimal 02, it says, where am I? On the next page, it says applicable penalties under the law, which seem kind of nebulous. I was wondering if we knew what those applicable penalties under the law are.
Attorney Veloso?
The language there is designed, in a sense, as a catch-all phrase, in case there are state law provisions or our local regulations that are implicated by the language in 7.02. So I am aware of some criminal laws that apply, such as over-service, not selling to intoxicated patrons, things of the like. It's also, the language is designed so that it parallels that of traditional special licenses. The idea behind the 7.02 special requirements for certified art galleries and museums was to allow for minor amounts of alcohol to be sold at an art gallery or a similar presentation, namely minor wines and champagnes.
So
However,
what you're saying then is that we're putting them on notice that can be in trouble with us, and they can also be in trouble with the police and the DA.
well, essentially, they have the same responsibilities as anyone who would hold a traditional special one-day license would, simply because of the fact that it's a special art gallery or museum special license doesn't preclude the fact that they are still bound by the same laws, the same rules, and the same regulations that someone who would hold a traditional one-day special license for alcohol does. So the purpose of the language is to remind those that take a special one-day license for art galleries and museums that they are bound by the same laws as
Right.
anyone else in the Commonwealth.
Right, makes sense.
And then for the update, I'd just say that whatever we do, we should put a new update date and then drop the manager's subject to thing, because I don't think it adds anything. What I'd like to propose, I guess I have to make it a motion, is that we take a look at the format and edit issues and
Come back the next meeting.
come back to the next meeting, and I'd request that Ryan put the comments up on the website so that if anybody wants to look at them and make comments and add to them,
That's fine.
that would happen.
Why don't we hold off on the motion? I have something that I'd like to bring up.
Oh, good you said that, because I had one more thing that I forgot about. Go
Okay.
ahead, you first.
And I'll let Attorney Veloso chime in and Secretary Nguyen, but in my tenure here, the majority of the agenda items are special one-day licenses, be it from the Holy Ghost but we always have the same people coming in here for those one-day licenses. And to me, to have them continuously come down here for the same type of license is redundant. I would like to see them come here at the first of the year, apply for the licenses. We tell them exactly the responsibilities that are needed, and what the repercussions are. And the next time they come, they just go to you, Ryan, they apply for the license, and at our next meeting, just a summation of, you granted these licenses. To me, and I'll ask Attorney Veloso from a legal standpoint, if this is something that we can and can't do, but to have the same people come here every other week, or once a month, or once, it just seems to me that they've got better things to do, especially if they're responsible in their licenses that we've given them. I see no reason for them to be coming down here all the time. So I'll open it up to the board for discussion, and Attorney Veloso, I'll let you chime in as well.
Well, we can certainly look at the law and see if that can be done. One potential option could be, and granted, it depends on what state law allows, but one way you could do it is perhaps batch it. So you could divide the year up perhaps into increments, winter, spring, summer, fall, and then if your organization or you're going to be holding certain specific events that would require a special license, maybe you could designate a particular license commission meeting at the beginning of that period of time, have them come in, present those special license applications, and then have the board sort of do it in batches. That way, you at least have some follow-up throughout the year.
That may be difficult for some of these people that do come here that don't know in advance what those scheduled dates are going to be. So, they do come 2 or 3 at a time, but, if somebody's renting a hall, let's say at the Holy Ghost, that type of thing, they don't know 3 months ahead of time.
Mm-hmm.
What I'm saying is that tonight we had 5 from the Holy Ghost. You know, last week, there were 3 from them. We've had from the Art Gallery, we've had from different places. We're gonna have them from Merrimack Repertoire Theater. You know, we've never had problems with any of these people that have held these one-day license, and to have them continuously come here, and for me and this board to say, you know what, you gotta do this, you gotta do that, well, we've already told them that. It just seems very redundant and tedious to me to continue that. But I'd like you to maybe talk with Ms. O'Connor maybe, and, you know, come up with something, but I'd like to hear from the board what the thoughts are on that subject.
Certainly, and the law department can certainly look at that issue and see
Thank
if
you.
state law would allow for sort of that sort of
I
setup.
appreciate that. Maybe you can come back to us in a couple of weeks with maybe your opinion.
Certainly, we'll take a look at it.
Thank you. Anybody else from the board on, any discussion on the subject?
Just,
Commissioner McCarthy?
on some of the ones that come so frequently, could some type of a special license be granted them to cover them for the year?
That's-
With a fee?
That might be something that Attorney Veloso can look at. Now, mind you, if you're coming for a malt and wine beverage license, but then the next time you want an entertainment license, I would say that you would have to come back here for that entertainment license, you know, that type of thing. But if it's in the case of the Holy Ghost, that type of thing, they have an all liquor license, and they've had now, I believe, if I'm not mistaken, that will be 38 events from that establishment. So,
Well, if I can, yeah.
absolutely, Ryan, please.
There are certain venues, such as Holy Ghost Park, and the circumstances by which the Holy Ghost Society has chosen to operate their facility, where they apply for the special one-day licenses. And I think the character of the individuals applying for these one-day licenses is excellent. I don't think there's any reason to think they wouldn't comply with statute and state law. Presumably, they understand what their responsibility is, and I don't think there's been any complaints about the facility, Holy Ghost Society, other than in the summertime when we have the outdoor amplification, where there have been issues on that. But otherwise, the alcohol service and sale at the venue, Holy Ghost Park, has not been a problem.
Well, take an example, Mr. Lachulis was here tonight. We have the lady who's from the Art Gallery, she's here quite a bit. You know, what you just said, I mean, the character of the person, obviously, you know, somebody else, like, I believe the person from the Holy Ghost who had the 30 licenses, and then Ms. Menendez came here, we would like to see her again, obviously. But once I've seen them, I'm all set.
Okay.
I don't need to see them anymore.
And I can well appreciate what you're saying, and I would trust I believe you are right in what you're saying about this particular applicant or that particular applicant.
Sure.
But not necessarily can it be said of each and every applicant. And some applicants are first-time applicants, and obviously you would need to meet with them.
Sure.
With respect to Commissioner McCarthy's comment, licensing authorities, like the License Commission, of course, are structured within the confines of Chapter 138 of the General Laws, which is the Liquor Control Act. And other than an annual license for on-premise consumption, like a license that's issued to a hotel, a restaurant, a club, which is a members guest type club, the only provision available in the statute is to grant one-day licenses. There is a provision in the law where, like an educational institution could have a license for like a cafeteria if they were serving alcohol. Let's say the alumni club of a particular university had a place where they would the members of the alumni would gather and socialize and hold meetings. They may want to have an alcohol beverage in that place, in that room. That would be something where the licensing board could grant a license for that particular entity, for that institution, on like an annual basis, or at least if not an annual basis, for a period of time during the course of a calendar year.
Right.
Otherwise, there's nothing available, so that if you were talking about again, the point of being, and I don't want to single out in a bad way, just in a favorable way, the Holy Ghost Society and the Holy Ghost Park, they chosen to come for the one-day licenses, but it does now allow itself, if they wish to apply for a club license, they could, as a club, which is a members and guests, which we could theoretically open their facility to rentals. For example, you rent the facility to like a wedding reception, or which is typical of some events, most events that they may have at the Holy Ghost Park, so that they could offer that alcohol. Otherwise, there's nothing available in the statute, and that's where we have to go with that first. That's our lead, and then we take it from there. So when the licensing board grants one-day licenses, then there is the ABC regulation, which stipulates not more than 30 to one individual in the calendar year. And the only venue that has more than 30 events in a calendar year is Holy Ghost Park for the one-day license application.
Okay. Attorney
Well,
Veloso?
Holy Ghost and also MRT.
Now, the MRT is kind of like of a different complexion, if I may say that, is that they're seasonal type of a license. They're seasonal in the sense that their performances don't begin till late fall or early fall, actually September, I should say, and they run through until the beginning of May, and they have like 4 or 5, maybe 6 various productions. So it's not like a continuous operation day in and day out. It's only when and their dates of their scheduled theatrical productions usually are like within a range of like 20 days. And then that show ends, or that performance ends. Then they have a downtime.
But once again, if the same person is applying for the license,
But here's where we have what the commission has done for the MRT, if I may.
Sure.
The 2 gentlemen that were just here are coming in for 2 separate scheduled performances of the Merrimack Repertory Theater. One production starts this evening, will run through the middle of November. The second gentleman came in, Mr. Prescott, will come in and he'll pick up the license for the performances starting November 28th through the middle of December, just before Christmas. So there's that. So they're covered in.
So this is sort of like the batching that the counselor suggests for the MRT.
I'm sorry, say that again?
batching, basically, what Attorney Veloso mentioned, kind of batching the
Yes,
licenses
but
together.
but they're singular different, they have singular nights, singular dates for specific performance in which they've scheduled it such that they're only going to serve their alcohol before the production begins that evening, and then during the intermission, and that's it. It's not like an after show sale.
Why don't we do this? Why don't we have legal counsel work with you, Ryan, on this? I mean, I don't want you to spend weeks and weeks on this, but I just think it's something to take a look at. And if it doesn't, if legally it doesn't work, then we won't do it. But I just thought it'd be something that we need to look at.
Yeah, certainly, we can take a look at it, definitely.
Commissioner Krieger?
Yeah, I've got one more, and then maybe we've jarred some ideas loose amongst the citizens here. Someone suggested to me that we make it mandatory that every licensee submits an email address, and that the agenda, the minutes from the last meeting, be blasted out to all of them via email, just to make sure that they know what's going on. And if we put some sort of a paragraph in our rules, we could invite citizens groups and citizens to add their emails, so that this is just an additional way of getting the word out to people about our meetings, what's on the agenda, and what we talked about last time.
Why don't we, just an idea to throw out, Commissioner Krieger, when they're applying for their next year's license, maybe offer that as a, would you like to have this?
It is requested of each and every licensee when they file their renewal application, and it's happens in in 2013, I should say, and even in 2012. That application has a box which allows the licensee to record a email address. And when, follow up on what Commissioner Krieger just pointed out, I relied on many of those email addresses that were provided in their renewal application from last year, last November. Not all of them recorded an email address. So for those that didn't get the, didn't have their email address on the renewal app, I just sent to that business the hard copy of the notice and the actual,
But if they wanted copies of the city council minutes, or, you know, what the agenda is gonna be for the following, I think it might be something that they, you know, they may or may not want.
yeah, but I would certainly, you know, once I get the situation, you know, composed where I can have all those email addresses, like I do with the neighborhood groups.
Sure.
All of the neighborhood groups that I have record of are sent an email address. I sent the agenda each and every time. In fact, I don't know if there was anyone here from any of the neighborhood groups, but I could assure you, Commissioner Krieger, that, and Commissioner, and all members of the board, is that the neighborhood groups were notified of this evening's hearing on the, public hearing on the regulations.
Okay,
So,
good, I think it's great. You got one? Fantastic, all right. What is everybody's general thought about something, about getting the agenda, and? Right. You think would like to know about the the commission's minutes prior and upcoming agendas and that type of thing? I think it might be something that the public might, the licensing holder,
yeah,
why don't we do something like that?
that's easily done. I don't think you need a regulation, but I mean,
No.
that's your prerogative.
If they do, they don't, you know?
I would happy to send anyone an email, send them an email of any document I have that's public record.
If I may, there might also be an easier option. The city website, in the city clerk section, has a tool that is used to track meetings, and with that calendar tracker, they also have a section where you can access meeting minutes and PDFs of items that are presented before, say, the city council or the school committee.
Would Councilor Velosa like to withdraw the use of the word easy
Well,
with regard to the city website?
I can't speak as to that. It is an option.
Let's not go there.
The gentleman, I've accessed that in the past. The minutes aren't often posted quickly. So if you're looking for a meeting and you're busy, you go look maybe the day after, 2 days after, 3 days after, and it's on your mind. You go look, and then it's gone. And oftentimes they're not up yet. You know, that's a secretarial issue or whatever. Whoever's going to post it needs to post it. So some of the times I've looked over certain things, and it hasn't been, and then, 4 days later, I forget totally what I was looking for.
More reason for the emails. I like it. Any other further business, any other discussion from the board? Because I'll open it up to the audience on any ideas, suggestions. You know what I want to ask you, Ryan, actually? The licenses for this year, how many of the establishments took the cut, like, meaning if they were gonna stay open until 1 o'clock, 12 o'clock, or 11 o'clock? How many did we have that did not, not the 2 o'clock, basically? Did we have a breakdown of what the licenses?
As far as the option they selected is not to have the 2 a.m. closing,
Right.
and wanting to close at an earlier time.
Yeah.
I would say about a dozen businesses opted to have an earlier closing,
Okay.
specific to either be at 1 a.m. or 12 midnight.
Have any of them come back and asked for 2 o'clock again?
No, in fact, the businesses that took advantage of the opportunity were already closing earlier. They were just tickled to death that their license fee was being reduced, in some cases dramatically.
What a city. What a city. Huh?
So it was just a first time the city ever gave them a nice.
That's good. That's good. All right. I'll open up to the audience once again. I know many of you have been patient here and listened.
But if I could just, one on that last subject, coming this time around, anybody who wants to choose to have a earlier closing than 2 a.m., certainly can let it be known and put it in place for the new
Upcoming.
license.
Okay, even better. Anybody like to? Sir, state your name, please.
Joel Azadorian. I was just going to make a suggestion as opposed to a question. I would love to see public transportation running later in the evening, and just to help with, clients that have drank and just wanted to be able to get home, locals. And I thought that would be extremely helpful.
I think that might be something you might want to contact one of the city councilors, that they could join forces maybe with the LRTA. I think that might be the avenue to take rather than this board. But if you don't get anywhere, please feel free to give us a call. We'll get it forward. But I think any city councilors, we can get their phone numbers from the website. That might be the avenue. City councilors would probably be the way, and then just so they can address it with the LRTA maybe, and maybe they can come up with something. Especially with all the UMass Lowell students that are frequenting downtown now, it's probably not a bad idea, and not a bad time to maybe bring it up.
Even just walking down the street instead of just, a lot of people are local, I'm imagining,
Yep.
especially with UMass Lowell, and I just think it would be a service.
UMass runs buses. UMass runs buses.
Please?
Yep. For that particular reason.
Great. Anyone else? Okay. Anything else from the board?
I had that motion that.
Oh, there was the
sort
motion.
of suspended, which says,
So we're gonna have a motion to, for our next meeting, to review the addendums or grammatical errors that were
Yeah.
brought forward, and bring them to the board for our next meeting.
and ask Ryan to get that published at our website.
Okay. Motion by Commissioner Krieger, seconded by Commissioner Hogan. All in favor signify by saying aye.
Aye.
Anybody opposed? That passes. Do I have a motion to adjourn?
Motion to adjourn.
Motion adjourned by Commissioner Krieger, seconded by Commissioner Hogan. All in favor signify by saying aye.
Aye.
Any opposed? Good night. Thank you for your attendance tonight.
Thank you all.